Hello everyone and welcome to this video tutorial in which we're going to be looking at an exam question for the tort law exam, and today we're looking at an evaluation question that could come up on the area of private nuisance. And the question that we're considering today is here at the top of the page for you. You're being asked to discuss the extent to which the law of private nuisance creates an effective balance between the rights of neighbours in their respective use of land. And you'll notice that I've highlighted the word balance there because that's really important in this question. To answer this question well, you have to do two things. Firstly, you're going to need to outline the law, so that is all the rules and all of the key cases on the law on private nuisance. And secondly, you need to analyse and evaluate those concepts and cases in order to discuss whether the law is striking a balance between the two parties. And that's really what the law is trying to do here. It's trying to balance the two respective rights, the rights of the defendant to use his land for the purposes that he wants to, and also to balance that, of course, with the rights of the claimant, who typically in private nuisance just want to have quiet enjoyment of their land without any sort of interruption from the defendant. So the law's having to do a difficult thing, really, in balancing these respective rights. So by explaining the law and the cases, we're going to be tackling that question to really say whether we think the law is doing its job effectively here. I've colour-coded my suggested answer for you here to try and make it a little bit easier for you to follow this on the screen. So I've used two different coloured fonts. So black font is where I'm just giving an explanation of a fact. So it's just description, if you like. It's a fact, it's a case, it's a statement. And the red font is where we're demonstrating a higher level skill for the exam, which is particularly relevant to these evaluative questions, where we're analysing the rule or the principle that we've just described. We're analysing it, we're evaluating it, we're discussing whether it's fair or not. And for this particular question, wherever we possibly can, we're going to refer back to the question and discuss whether that case or that principle shows that the law is trying to balance two conflicting rights. So to start off with then, I've given a little definition of what private nuisance is. So private nuisance is an interference with a person's enjoyment of the use of their land. And there are three main forms of private nuisance. Nuisance by encroachment onto a neighbour's land, that's typically where a tree or something like that is going onto the neighbour's land. Nuisance by direct physical injury to a neighbour's land, so clue is in the name there, a fence being damaged or something like that, or nuisance by interference with a neighbour's quiet enjoyment of their land. And that's really what we're considering here. And I've got a little bit of red font here, some analysis happening. The rules on nuisance are designed to balance the rights of neighbours in the respective use of their land. So you can see I've linked back to the question. And now we need to outline the different rules on private nuisance. So after our introduction, we've got the first sort of fact, if you like, about private nuisance. Not all annoyances are actionable. And you could use the case of Hunter and Canary Wharf here, where Lord Lloyd stated that just because something is an annoyance doesn't mean it's going to be actionable in private nuisance. I think that's a pretty logical rule because we wouldn't want a situation where people were suing each other for every little annoyance that cropped up between neighbours. Interference with the TV reception is not actionable. That was shown in the case of Hunter itself. And interference with light is not actionable, and that comes from the ancient case of Berry and Pope. And also interference with a view is not actionable in private nuisance either. So in terms of evaluating that rule, it could be said that the law on private nuisance is not effectively balancing rights here, because these annoyances with your TV, with your light, with your view, they're not actionable despite the fact that they were clearly interfering with the claimant's enjoyment of their land. I know I'd be very unhappy if my TV reception was being interfered with. So it looks on the face of it that those particular interests are not being balanced effectively. So not all annoyances are actionable. And once we've checked that it's not an unactionable nuisance, we then have to look at the three requirements of a claim. So while claimant must have an interest in the land, there must be an unreasonable use of the land, and the claimant must suffer some harm. And by listing those three requirements, that gives us a little essay structure really to go through. We're going to explain each of these rules and evaluate as we go. Firstly, in the case of Malone and Lasky, it was held that the claimant must have an interest in the land in order to sue. And you could say about that it seems unfair on claimants, such as the wife in the case of Malone, who wasn't able to sue for injury simply because they do not have an interest in the land. So again, that sort of suggests that perhaps the law isn't balancing rights as effectively as it could. In deciding whether the use of the land by the defendant is unreasonable, the court's going to consider several factors, including the sensitivity of the claimant, the time and duration of the nuisance, the character of the area, any utility of the defendant's conduct, the reasonable foreseeability of the type of damage, and any malice on the part of the defendant. And the fact that there are so many factors there to consider makes deciding whether the action is unreasonable very complicated for the courts. And this makes advising clients difficult. All these different factors make it difficult to decide in which way is the law going to go. And arguably there you could say, are we balancing rights effectively? If it's just so complicated, so confusing, we're not really able to predict with certainty which way it's going to land. In Robinson and Kilvert, it was held that a claimant will not succeed in private nuisance where he's abnormally sensitive or his trade is abnormally sensitive and an ordinary user would not have been harmed. Now, for us lawyers, that actually seems like a really strange principle because it conflicts with the thin skull rule and the idea that you have to take your victim as you find him. And it might actually be quite unfair for sensitive claimants to be denied a claim. So again, is that balance right there? Moving on to Crown River Cruises and Kimbolton, it was held that generally the courts require a private nuisance to be a continuing state of affairs. And I think that makes sense. It seems logical that the longer something goes on for, the more likely it is going to be seen as a nuisance. But the case did hold that it can be a one-off event. And that seems fair because a one-off event can still be a real nuisance to a claimant. But on the other hand, we could argue it's unfair to penalise a defendant for something that only happened once. It's not a continuing state of affairs. The character of the area is relevant in considering what's a nuisance, and I think this is quite controversial. So we've got Heroes here, where it was said that people who live in industrial areas can expect more noise than in a rural area. And then in the case of Sturgis and Bridgman, we have a very famous quote here that I've included from the judge. What would be a nuisance in Belgrave Square would not necessarily be so in Bermondsey. And this could be seen as being unfair, or in other words, not adequately balancing rights, because claimants are being penalised depending on whether they live. And it's arguably unfair that those who happen to live in industrial areas are not entitled to the same actionable nuisances as those who live in the countryside. Coventry and Lawrence, we had a Supreme Court decision here that said that planning permission doesn't necessarily mean an activity is not a nuisance. And that seems quite strange to me. It's a surprising decision, I think, because planning permission, surely the whole point of it is to take into account the effect on the area when this is happening or when it's finished. So that seems a little bit surprising, perhaps. Surely the idea of planning permission is to balance rights, and it should be taken into account there. We've then got Miller and Jackson, a case which makes me smile because if you remember, this was a Denning case and Denning loved cricket. And in this case, it won't surprise you to know that Denning refused an injunction for nuisance that involved a cricket ground on the basis that the public interest in having a cricket ground far outweighed the risk. And it could be said that this is unfair because different people will have different views on what's in the public interest. And I've actually put there that Denning was a keen cricket fan, and this might have affected his decision in the case. And I think it probably did. And again, you could link that back to the question there by saying, you know, arguably, are we balancing rights adequately? Is it coming down to the judge's own discretion and their own views? Arguably, it shouldn't be. That's not particularly democratic. We've then got the wagon mounds, where it was held that the type of nuisance must be reasonably foreseeable, and that could be unfair for claimants to lose out on a claim simply because the nuisance wasn't foreseeable. We've then got Christie and Davy, again an old case but a very famous one, where the claimant was a music teacher who gave lessons in her home, and the defendant was annoyed by the lessons, so acted with some malice by beating the walls, shrieking, banging metal trays whenever lessons were going on. And our claimant succeeded in getting an injunction against the defendant because it wasn't a legitimate use of the house, the land. And they were talking about the fact that beating the walls, shrieking, was not a legitimate use. In other words, the defendant wasn't wanting to do that anyway. Its sole purpose was to annoy the claimant. And it seems reasonable that defendants can and should be penalised if they're deliberately trying to annoy the claimant. Coming to the nuisance is not a defence. You could use Miller and Jackson, Sturgis and Bridgman there. And this seems reasonable because a claimant shouldn't suffer simply because they've moved house unaware that a nuisance was happening. And then we're starting to get towards the end here, so I'm outlining some defences. So there are two main defences to private nuisance: statutory authority and prescription. And it's a defence to private nuisance if the claimant can show that his conduct was authorised by law, and many nuisances are caused by activities undertaken by local authorities or other bodies acting under statutory powers. They might be rebuilding a road or something like that. And if the actions are within the scope of the statute, they're authorised by Parliament, they can't be challenged by the courts. Prescription, on the other hand, is a bit of a weird one. It's a claim by the defendant that he's acquired the right to act in a particular way because he's been doing it for 20 years or more, as in Sturgis and Bridgman. But both of these defences do make it harder for the claimant to claim in nuisance, again, arguably affecting the balance for the claimant in this area. And now reaching a conclusion. In conclusion, the law on private nuisance is quite complicated. It's difficult for the claimant to succeed in a claim because they have to have an interest in the land. They have to show the use of the land is unreasonable, and that really depends on the facts, as we saw in Miller and Jackson with Denning. Not all annoyances are actionable anyway, like the TV reception, light and a view. There are a number of defences which make it even harder to succeed. So in this way, on balance, after having gone through all of those cases, it does appear that the law struggles to balance the rights of neighbours. And it's always nice, as I've done here, to refer back to the wording of the question in your conclusion, so the examiner is certain that you've answered the question and you understand what was being asked of you. So I hope that was helpful to you. Remember that I do have other videos on my channel on private nuisance and on other areas of law too, so please have a look at those. And if you do like the videos, if they are helpful, if you can like them and subscribe, it really does help me to make more content for this channel.